So I'm going to go ahead and start talking a little bit. So my name's Lacey Brown. I'm with South Dakota State University Extension. My office is here in Rapid City, and kind of part of the role of Extension is to bring information to our communities that people want. And this webinar series is something we started last fall, and this is a topic that was specifically requested. So I'm going to let Jane Strumman from NDSU Extension briefly introduce herself, and then we will turn it over to our speaker, Kimberly, who will introduce herself to you. Jane?
Thank you, Lacey. Yes, I'm Jane Strumman. I am the Gerontology Specialist with North Dakota State University, and we are just pleased to be partnering with SDSU Extension and Lacey, bringing these webinars to both of our states and beyond on important topics. And we're so pleased to have our guest presenter, Kimberly, joining us today. So thanks for participating.
All right, we're going to get started here. Our webinar today is Who Do You Trust With Your Money? Elder Abuse and Financial Exploitation. This is part of my program is with the Attorney General's office, so I always got to throw that up there for you guys. So who am I? For those of you who don't get to see my pretty face, you get it there in the slides. My name is Kimberly Zackerson. I'm the Assistant Attorney General. I handle the Elder Abuse and Financial Exploitation Unit for South Dakota. A little bit of my background is 7 years prior to this, I handled domestic violence and sexual assaults for 14 counties here in South Dakota. That is 1/5 of the state of South Dakota is what I covered. Then in June of last year, I transferred over to the Attorney General's office and became the prosecutor for the Elder Abuse and Financial Exploitation Unit. Our unit was created back in 2016. Our legislature put together the Elder Abuse Task Force. Out of that task force came a bunch of legislation, and then our Elder Abuse and Financial Exploitation Unit. Our unit is currently composed of 3 individuals, myself as prosecutor. We have Agent Brett Spencer, who's the coordinating investigator with the Division of Criminal Investigation. And then we have a computer analyst, Chase Coolman, that handles all of our bank records and any type of records we get in for our cases. He gathers them and puts them together in actual format that I can understand and I can explain to a jury. So Brett and Chase are very important to our units and for my prosecution of these cases. At any point in time, if you have questions during this webinar, go ahead and type them into your chat box, and Lacey and Jan will take a look at those and we'll handle some questions at the end. Then you don't have to try and remember them as we go through and wait till the question time at the end. So let's get started here. What exactly are we dealing with? Elder abuse in adults with disabilities. It is against the law. Abuse to these individuals is against the law. It is underreported and it is predictable. Now, most people don't think that it is predictable, but once you start knowing the signs and being able to recognize the signs, you'll see how these things are predictable. Unfortunately, these things do cover all communities, urban, rural, it doesn't matter where you're from. These cases will hit you, and unfortunately, these cases are on the rise due to our continuing older populations. These are difficult cases to prosecute and to even talk about for many people. Because most of the time, the person doing this is a family member. And if somebody's hurting you as a family member, it's really hard to talk about or even report it. These cases are underreported most of the time because the victim feels shame. As someone who's getting older, they feel like they could take care of themselves, but unfortunately they can't, or something is happening in their life and they don't want to talk about what's happening to them. Many times a victim won't report what's going on because they feel a loss of independence. As you get older, you want to have that independence. You want to be able to go out there and do things on your own. And the older victims are afraid that they're going to lose some of that independence that they work so hard for if it's discovered that they are being abused or victimized. Many Many times we see that there are threats that are associated with these cases. Sometimes that's why a victim won't come forward. And many times these cases have a long-lasting effect on everyone involved, not just the victim, but their family and friends. So let's talk about what is abuse. Abuse can come in many forms. The three main topics that we talk about dealing with abuse is physical, emotional and psychological, or financial abuse. Now, we're not going to dig too much into the financial stuff today, or excuse me, the physical. Don't worry, we'll talk about financial, about the physical stuff, because it's what you think of as physical abuse. It is striking, hitting somebody, kicking, causing bruising, damage, cuts. That's physical abuse. Emotional or psychological abuse, that's kind of a new concept for many people. Back in 2016, we just created statutes here in South Dakota about that. And there are some states throughout the country that don't even have statutes regarding emotional and psychological abuse. But we'll talk about it because it is connected to the other types of abuse. Excuse me. Getting over a cold here, so sorry about that. And then we will go into the financial abuse, because that's the one most people want to hear about. So emotional and psychological abuse mostly come in 4 different types. A sexual act or simulation of a sexual act. Now we're dealing with elderly individuals and adults with disability. Most of the time, people don't think of sex acts connected to that group of people, but they do exist, it does happen, and we have to make sure that it's out there and people know about it. Unreasonable confinement, it's pretty much what you think. Forcing someone to stay inside a home, not letting them go out, stopping their independence. Harm, damage, or destruction of property or pets. This has a very psychological effect on people when their personal property or their pets that they care and love are being hurt and damaged. So it's very important that we are aware of this. In South Dakota, we have an actual statute that makes this a crime. For those of you who know anything about domestic violence, we see a lot of this also in domestic violence. Now, this fourth one here is what most people think of when they think of emotional and psychological abuse. It's ridiculing or demeaning conduct, derogatory remarks, verbal harassment, or threats to inflict harm. This is sometimes hard to distinguish between just the caregiver really frustrated or actual abuse happening. It's the yelling at them constantly. It's the why can't you do anything right? That's the type of things that we're seeing in number 4 there. If you see anything about it, it's not your job to distinguish, is this just a frustrated caregiver or is this actual abuse? That's not your job to distinguish. That's for law enforcement and prosecutors to distinguish. So don't worry about that. Now we're getting to the good stuff, why everybody's here, right? But the financial exploitation. In order to have financial exploitation, you have to have some type of duty. The person has to have a duty to provide support for an elder or an adult with a disability. Now those duties can come in one of 4 ways. It can be voluntarily, means you volunteer to take care of somebody, financially or physically take care of them. By written contract. This is done many times, we'll talk about later, like a power of attorney or a trust or some other type of written document between you and somebody else. Receipt for payment of care. This is done many times when we're dealing with like nursing homes or care facilities or even someone doing in-home care. Or it can be done by an order of the court. And we'll go into some of those types of orders from a court. Along with the duty, you have to be entrusted with that person's property. So you can't just say, hey, I'm going to take care of them, but then don't have any duty to take care of their property or their finances. If so, then we're not into financial exploitation. When they have that duty and are entrusted with that property, they have to be using the property in an unlawful manner. If they're not using it in an unlawful manner, then we are not getting to, then it's not financial exploitation. Then it's not a crime. When they're using that property in an unlawful manner, they must do it with an intent to defraud. And in the parentheses, there's kind of the definition of intent to defraud, which is to cause injury or loss to a person by deceit. I know we're dealing with people from all across the country here, so your state may not say these specific words, but it has these concepts when we're dealing with financial exploitation. Almost every state requires some type of duty and some type of property being used unlawfully. The different types of intent may be different, but it's the general concepts seem to exist across the country. Victims' capacity. I put this in here because we are dealing with people all across the country. There are some states that require you to also determine the victim's capacity, what their mental capacity is for agreeing to some of these things. In South Dakota, we don't require proof of the victim's mental capacity, but in some states they do, such as in North Dakota. North Dakota has two different statutes. One statute does not require you to talk about victim capacity. The other statute does require you to talk about victim's capacity. And when we're talking about victim's capacity, we're talking about whether or not the victim was capable of consenting, if they have dementia, Alzheimer's, some type of mental disability, or anything like that. I put this out there because there are some states that do deal with the victim's mental capacity, and I wanted to make sure that you were aware that that does exist. So, how do people get these duties? Well, they get them voluntarily, like we talked before, or they can get them one of these other four ways: through a guardianship, a conservatorship, a power of attorney, or a trust. So guardianship is a person who is appointed by a court to be responsible for someone else's personal affairs. So guardianship is one of those that a court actually has to appoint you. It's not something that you can walk down the street and just pick somebody out and say, hey, you're my guardian. It doesn't work like that. A judge has to order and appoint the person to do that. When we're talking about guardianships, most of the time people think of an orphan child or a child where a aunt or uncle is now becoming the guardian of the child when the parents can't take care of the child. That's what most people think of when they think of guardianships, but they do exist with other individuals, as we're going to talk a little bit more about. Conservatorships, that's another type here that's ordered by the court. Conservatorship involves a person being appointed by a court to be responsible for someone's estates and financial affairs. You're going, okay, that's great. What does that mean? Conservatorship, again, is something that's appointed by the courts, so a judge has to come in and say, you're in charge here. And we're dealing more with someone's personal estates and financial affairs. So what's the difference between a guardianship and a conservatorship? Well, a guardianship deals more with the day-to-day activities, dealing with getting someone to and from doctor's appointments, making sure they have clothing, food, medications, things like that. Conservatorships deals with the overall financial decisions. That's when you're dealing more with property like housing, estate planning, trust, some things like that. They're a little more broader than the day-to-day activities. When we're seeing guardianships exist with with juveniles and younger adults, we're seeing just normally a guardianship exist because those people just need somebody to help with the day-to-day activities. Whereas when we're dealing with older adults, we're seeing a guardianship and a conservatorship most of the time because you need somebody to deal with that day-to-day activity, but also you need that conservatorship to deal with more of the estate planning aspects of it. So if we're dealing with an older adult, many times a court will order both a guardianship and a conservatorship. A power of attorney. A power of attorney is a person you appoint to handle your medical, financial, or legal matters. So this is one that you actually have control over, and you're the one that appoints this person. The three main types of power of attorneys that exist out there are the medical, the financial, and the legal. The medical comes into play most of the time when you are unconscious or incapacitated, where you can't say, this is what I want to happen to me medically. And that's where the medical power of attorney comes in place, where somebody else comes in and talks about what's in your best interest medically. So that's pretty straightforward. Financial power of attorneys come into play in two different scenarios. One scenario you can have is when you are incapacitated, where either a judge or a medical professional has said you cannot take care of your own finances anymore. That's one way a power of attorney can come into play. Another way is you appoint someone and you have control over your finances, and the power of attorney has control over your finances. You both get to control the finances. So that's kind of a little difference with the financial power of attorney. A legal power of attorney exists when you want someone else to go to court and handle your civil claims, such as you're suing a company and you want, or you're getting a benefit from a will. You're a beneficiary from a will and you want somebody else to handle all the paperwork involved with that. That's more what a legal power of attorney is. Another power of attorney exists out there is for military individuals, for when you go overseas, and you can get a military power of attorney. So when military personnel are overseas, they can have somebody back home here in the States handle all of their, anything they have going on here in the States. So that's another one that exists out there. Next, we have our trusts. Now, trust gets a little bit more complicated. A trust holds assets on behalf of beneficiaries. So if you make it, so a trust is like an imaginary box, and you take all of your assets, your property, your money, your house, whatever, and you throw it into this box, imaginary box. That's your trust. Now, only the people who are beneficiaries can get benefits out of this imaginary box. So you make a trust, you no longer own the property. The trust owns the property, and you may become a beneficiary of the trust or a beneficiary of this imaginary box. The person who actually creates the imaginary box or the trust is called the trustor, and they create the whole trust in themselves. Then you have beneficiaries, and it's someone who benefits from a trust. So you can put all your stuff inside this imaginary box, and you can become a beneficiary of it. So anytime something comes into the trust or the imaginary box, and you can get like a payment out of there, or you can use the land or something along those lines. But it all has to stay inside the imaginary box. The trustee is the person who is in control of the trust assets. So it's the person who's actually in control of the imaginary box. So say you have some property that's in your trust, and you're renting that property out to a rancher, and that rancher has to pay ranch monthly payments on that land. Well, when the money comes into the trust for those rent payments, it's the trustee that then takes that money and then divvies it out to the beneficiaries. So that's how we have those imaginary boxes and the trustees and the beneficiaries. So who can get appointed to these 4 categories? Most of the time, it's going to be a family member. Parents, a child, a sibling. We've seen aunts and uncles, cousins, nieces and nephews, occasionally grandparents. But most of the time, it's going to be a family member who gets appointed. Sometimes we see a friend. When family members aren't close by, but a family friend is, sometimes the friend will be appointed as power of attorney or in a guardianship or conservatorship. A bank can also be appointed. Now, when you're dealing with trusts and power of attorneys, sometimes you want to have a bank be appointed on those things instead, and sometimes a court is more comfortable appointing a bank for a guardianship or a conservatorship. There are some rare cases, but they do exist, that an organization may be appointed. There are some organizations in every state that are willing to handle people's finances for them. They're not necessarily associated with the bank, but they're a separate organization, and you can find those in any of your states. So if you're appointed, you have a fiduciary duty, and that's one of those big fancy legal words that you have to deal with. Fiduciary duty basically means you must act in the best interest or to the benefit of the principal. You're like, that's great, but what does that mean? It means everything you do has to be for the benefit of that other person. So the principal is the person who actually created the appointment or the person who must be cared for. So in a situation where it's the trust or a power of attorney, the principal is the person who created the power of attorney. In a trust situation, the principal would be the beneficiaries. In a guardianship or a conservatorship situation, the principal is going to be the person that the court says you must take care of. Now, a fiduciary is the person who has been appointed. So in a guardianship and a conservatorship, the fiduciary is the person that the court orders or appoints to take care of the other person. In a power of attorney situation, the fiduciary is the person that you appoint to take care of your stuff. In a trust, the fiduciary is actually the trustee, which is the person who was in control of divvying out everything and controlling the trust. No matter what you're dealing with, whether it's a trust, power of attorney, guardianship, conservatorship, you have a fiduciary obligation. And that fiduciary obligation or duty is very simple. You always must act in the best interest of the principal. So if you get appointed to one of these, what do you do? One of the first things you should do is know what your duties are. Find out what they are. You can find that out by the documents that you're given. If it's a trust or a power of attorney, if it's a guardianship or conservatorship, you can talk to the courts, the judge that appointed you, or look at statutes. So know your duties and know what your limitations are. If you don't know these things, you can accidentally do something illegal, and you don't want to do that. So always make sure that you know what you can and cannot do when you get appointed. Document everything. I cannot say this enough. Document, document, document. If you are appointed, you want to be able to document and show that everything you are doing is for the benefit of this other person. It goes back to that fiduciary duty we just talked about. You want to make sure that you're documenting everything. You want to write down anytime money comes in to the estates or what you're handling. You want to write down every time you send money out and what it's for. Even if it's just the normal everyday stuff, like you're paying for the nursing home or you're paying for the food bill or the medications. You want to make sure that you're documenting that. So if somebody else comes in and says, hey, I don't think you're doing this right, you can show them all your documentation and say, look, this is what I was doing. Here's how it benefited this person. Do annual reportings. Now, when you're dealing with a guardianship and a conservatorship, most states require a annual reporting, which is you have to report to the court every year about what you were doing, how you were spending the money. Now, powers of attorney and trust don't always require an annual reporting, but my suggestion is do it anyway. If you're going to do those annual reportings, it's helpful because then you can show to everyone else, here's what I've been doing for the past year, here's how I've been spending the money, here's how I have been acting in the best interest of this other person. Sometimes it helps save you in the long run of someone coming in, especially siblings, coming in and saying that you're doing something wrong. If you're questioning anything, you can talk to the attorney that actually wrote the document. So if you are dealing with a trust or a power of attorney and you're not quite sure what you can and cannot do, you can always go back and contact the attorney who wrote the document and talk to them about it. You can also get your own attorney and talk to your own attorney about the document and what your duties are, what you can and cannot do. One of the things I cannot stress enough is do not ask your siblings, your friends, your coworkers what you can and cannot do unless that person is a licensed attorney in that field. Because many times what happens is you'll ask a friend or a family member or somebody saying, hey, can I go spend money on this? And they'll say, sure, that sounds okay. When in actuality, you can't be doing that because it probably violates the fiduciary duty or some of the limitations in that document that you're not allowed to do. So do not ask other people around you, go in and contact an attorney or contact the attorney that wrote the document. Also, you can go and review the statutes in your state. Most states have statutes regarding guardianships and conservatorships, and most states are starting to get statutes out there that are covering power of attorneys and trusts of what you can and cannot do. So that's another reference of something that you can go do and look at. So now that we've kind of figured out if you're going to be appointed, here's some other ways that you can go and protect yourself. We look into the factors for vulnerability of as we get older, who is more likely to be taken advantage of, who's going to be more likely to be abused or exploited, and we look at some of those factors. The first one that we look at is decreased mental capacity. And most of the time it's because we have people who have dementia, Alzheimer's, some mental disability, or just due to old age. Those individuals are more vulnerable and more likely to be abused or exploited. Lack of experience with finances. This is a big vulnerability for people. What we have been seeing is a couple and one person in that couple always handled all the finances. They took care of the house, the cars, the property, all the money at the bank. They took care of everything. And now they've died. So it's leaving one spouse having no idea about what's in the bank, what is going on with the house or the cars or any of the property. Because of this, those individuals who are left become very vulnerable to abuse and exploitation because they don't know what their finances look like. Individuals who have large amounts of money in a trust or bank, that is a potential for vulnerability or exploitation. Just because you got a lot of money in the bank though, good job for you, but it could be a potential vulnerability. Individuals who do not have close friends or family are potentially vulnerable to abuse and exploitation. We are a global society, and as people get older, they have a tendency to move farther away from family. And as we're dealing with older adults, unfortunately, some of their friends and family are actually dying, so they don't have them around. So that causes a vulnerability. So what are some ways that you can reduce your risk if you are hit one of those categories, or one of your friends or family does? One of the things you could do is speak to an estate planning attorney. There's estate planning attorneys all across the country. Most of the time, an estate planning attorney will give you a free consultation where you can come in and kind of just talk to them about what your thoughts are. Always double check with them to make sure the consultation, that first meeting, is free though, before you set up the appointment. As we get older, some people think, oh, I don't need an estate planning attorney because I don't have that much stuff. I just have the house, the car, and my Social Security check, and that's it. Well, even those few things could make you a risk for abuse or exploitation. So sometimes it's good to go just have that first conversation, and they may have some ideas where you can protect yourself a little bit more, even if you don't have that much assets. Require a yearly accounting. We kind of talked about this earlier with those people who got appointed, but one of the ways you can reduce your risk is if you're creating a power of attorney or a trust, is requiring that yearly accounting. Have it written right there in your documents. And one of the things you could do is have a separate company or person actually do the accounting. So say you have a power of attorney and you've appointed your son as your power of attorney. One of the things you could do is to have your daughter or a separate company have to come in and do the yearly accounting. That way then the son is held accountable to somebody else, not just you. Always double check with the company or the other person to make sure they're going to be okay doing those yearly accountings though, before you just name them as doing those accountings. Have a two-person check system. This is an easy, good way to reduce some of your risk. When you're having a power of attorney or a trust, you can appoint as many people as you want to be a power of attorney or the trustee. Now, I wouldn't suggest having a lot of people, but 2-3 people could be helpful. Because one person saying, oh, I'm going to go spend $5,000 over here on myself, well, the other person that's also your power of attorney can look at the accounts and go, hey, wait a minute, that's not okay. So that's an easy way to have more than one person being a power of attorney or a trustee. You can put your money into a bank. Have the bank be the power of attorney or the trustee in handling all your documents, especially if you have multiple children and you don't know which one of your children should be handling things. Sometimes it helps with the fighting amongst family members if you just put a bank or some other company in charge of the power of attorney or the trust. Writing a salary in your document is actually really good. The fiduciary, you can allow them to be paid for their services in controlling your power of attorney or your trust. But what happens many times is we see people writing in there a reasonable fee. Well, what's reasonable to you may not be reasonable to me for a salary. So what you can do is actually put in a specific dollar amount in your document that the fiduciary will receive as their salary during that time period. Specific language on spending. Some states out there have specific language that says you cannot self-deal or you cannot spend money on yourself if you are a power of attorney or a trustee. Unfortunately, there are some states out there that don't have that requirement and don't have those in their documents. So many times what happens is that gifting section on the power of attorney or the trustee will just say, oh, my normal, you can gift or give things out as my normal gifting patterns. Well, it's hard to tell people's normal gifting patterns. And what will happen is the power of attorney will then start just spending money however they want, not sticking to the limitations or the normal gifting patterns. And then they'll come back later and say, well, it says that I could do this. But if you put in specific language, like, you know, every year you're going to give $5,000 to each one of your grandkids, write that into your documents. Or if you know that every year you want to spend for your daughter's college tuition, you want that written in there. Go ahead and write specifically, I will spend for Brenda's college tuition. Put those things that you know specifically you want to have happen in there, and it will help reduce some of that risk. Learn about your own finances. We can't stress this enough. If you don't know about your finances, learn about them. It's as easy as just creating like an Excel spreadsheet or getting a notebook or a calendar and just writing everything down. If you are the spouse or the significant other in the relationship who handles all the finances, sit down with the other person and walk them through what the finances look like. You don't have to get in huge details, but letting them know that here's the house and here's what the mortgage payment is, and here's the car and here's how much the car is costs, and here's how much money we have in the trust account, and here's how much money we have in the bank, and here's what bills we have to pay out. It's something as simple as that. It's letting them know what the finances are, which is less likely for someone else to come in and start taking those finances away from them. Yearly mental check. As you're getting older, go and have your yearly doctor's appointments, get your physical, and talk to your doctor about any mental questions that you have with your mental capacity. If you start thinking that, hey, I might be showing signs of dementia or Alzheimer's or anything like that, talk to your doctor about it and make sure that they're putting those in your charts. And if they give you any recommendations, follow those recommendations. And if you're a doctor or in the medical field and you're listening to this, please, if anybody's telling you about those things, write those down in the charts. So if you suspect any type of elder abuse or financial exploitation, report it. But what are you looking for? So here's some of the signs that you can be looking for. Whether it's happening to you, a family member, or a friend, or just somebody you see passing by on the street, these are some things you can be looking for. I'm gonna have to pause here and plug in. Give me one moment.
Already got some questions in the chat box. Just a reminder, if you have questions, you can type them in the chat box and we'll address them at the end.
Oops. Sorry about that. Forgot to check the battery on the laptop today. So you can look for those behavioral signs, look for that social isolation, like what we talked about with that confinement earlier, and look for those signs of aggressive behavior, similar to what we talked about in that emotional and psychological abuse. For those of you who actually get to go inside people's homes, you can be checking out for soiled clothing or bedding. Look for that dehydration and malnourishment. For financial exploitation, we're looking at that misuse of money or personal property. Unauthorized sale of real or personal property. Those of you in the medical field, be looking for the frequent uses of the emergency room, the inappropriate use of the medication, the lack of necessary equipment. Now, this is something everybody can be looking at. If you know somebody who's always uses a walker or a cane or a wheelchair, and all of a sudden they're going around and don't have it, go ahead and say something. It's as simple as, hey, how you doing today, Helen? Where's your walker? I normally see you with it. You know, something as simple as that, and they want to chat with you. So go ahead and talk to them. Any changes you see in spending habits. If there's somebody who only spends like $100 a week, and all of a sudden they're spending thousands of dollars all of a sudden, that's very suspicious. Especially for those of you who may be working in banks, this is something to be looking at. So if you see abuse, who do you actually report this to? You can report it to your local law enforcement, your local state's attorney or district attorney. I know every state calls them something different, but it's your local prosecutor and your local Department of Human Services. These three agencies normally coordinate together in your state. So if you talk to one of them, they should be getting the information around to the other individuals. So what are they going to want to know when you talk to them? They're going to want to know name, age, physical address, and any contact information that you can give them about the elderly or the disabled adult, the reporting party, which is you, the caretaker, who's taking care of this person, and the alleged perpetrator. They're also going to want to know what is the possible abuse and how it came to your attention, and anything else you can think of that they should know. The more information you can give them, the more helpful it is in their investigation as they go forward. So resources, that's what everybody wants to know, is what else can I get for resources? So here's some things that you can do. The National Center on Elder Abuse is a really great resource that you can go and get information on. The National Clearinghouse on Abuse in Later Life is also a really good resource. Those are their websites here on our slides, and I believe our slides will be available after the presentation as well. I'm plugging in the SDSU Extension Office. There's their address there. If you click on Family and Older Adults, they have some really good resources. Whether you live in South Dakota or not, it's just general good resources. Also, the North Dakota Department of Human Services, that's their websites right there. If you click on Adults and Aging, they have some really good resources there as well. And it's not just for North Dakota. It's general information that can help you no matter what state you're living in. Another good resource is going to your Attorney General's office, because most Attorney General's offices have someone who is working with elder abuse cases now. If you don't know who your Attorney General is or how to get a hold of them, here's an easy way to find out. You can go to the National Association of Attorney Generals. That's their website, naag.org. You click on Attorney Generals, and it will give you the page of who's my AG. And you can scroll down that page, and here's just one of the pages that they look like. You can see your Attorney General, who they are and where they're from. And I just clicked on the one for South Dakota. And the nice part about this page is it gives you the physical address, the phone number, and the email address of your Attorney General. Also, this website is really nice because if you are in, say, South Dakota, but you're worried about your grandparent who's out in California, you can click on California and find out what the contact information for that Attorney General is, and you can go and talk to them. Another place you can go to is the Consumer Protection Division, which is at your Attorney General's office. They talk about a lot of the scams that are going on and can help you out with some of those things. So now is the time for questions. So Lacey, why don't you let us know what your questions are. If you've been firing questions, she'll let me know what those are. If you're thinking of questions now, go ahead and shoot them into the text screen, and Lacey will let us know. What you got, Lacey?
Kimberly, thank you so much. You did a wonderful job explaining some of these concepts that can be a little bit convoluted. So awesome. Thank you so much for doing a great job with that. So your first question from Doug: as a prosecutor, what issues have you seen in proving undue influence when dealing with movement or signing over of money?
Undue influence is actually really hard to prove. Many times when it's signing over of money, we're going back and we're looking at the document itself, what was leading up to the documents, and anybody who can tell us kind of what the situation was leading up to that. Unfortunately, the undue influence ones are really hard to prove criminally. Sometimes they're a little easier to prove civilly. And so a lot of times, if we have a criminal case going on, there's also a civil case going on as well. So hopefully that answered that question.
Thank you. So we have from Curious from Florida, where capacity is assessed. In the case of not assessing capacity, are those cases prosecuted more routinely?
And I'm going to say a little bit here about South Dakota. I'm not quite sure how they're doing it across the country, but one of the procedures that we do here in South Dakota is we focus more on the paper trail. We don't deal a lot with the victim because many times our victims do not have the capacity to help us. So we focus more on what can we prove based on the medical records, bank records, things like that. And most of the time it ends up being a paper trail, and we end up following a case and prosecuting cases without a victim being involved at all in our cases. So it ends up being the bankers, sometimes the doctors, but most of the time it's just our investigators doing a really good job following the money.
Awesome, thank you. So our next question. When dealing with a resident who has a declining mental capacity and meets all the requirements to have a conservatorship, guardianship, etc., how does a case manager try to get these services if autonomy is factored in?
Well, most of the time, if you're in a facility, you should have an attorney that's connected to that facility that can help you out with that. If you're not dealing with a facility, then most of the time you need to probably reach out to your own attorney, your own civil attorney, to focus on the conservatorship. You can also reach out to the local Department of Human Services, and many times they can at least help you at least start that process or get you in touch with the people who can help you with that.
Awesome. Okay, next one. What are some considerations if you are thinking about combining households to care for a relative?
Some of the things you probably need to consider is what assets do you guys have when you're combining households, and how are you going to manage to take care of. If it's an older person, you want to figure out what do they need in their best care. If it's they're dealing with some mental capacity issues, you want to make sure that you're focusing on who's going to be handling money, who's going to be handling property, and things like that, and kind of divvy it up amongst who's going to be handling what aspects of it.
So, okay. If you set up a trust, can you change it or revoke it? What might make you unable to change your trust?
It all depends on how you set up the trust in the first place. There are two different types of trusts. One is a revocable trust, which means you can actually go in and change it at some point in time. And then there are irrevocable trusts, which means once you create it, you can't do anything to change it. The easiest way to deal with whether a trust is revocable or irrevocable is to read the document itself, or I suggest contacting the attorney that wrote it, or your own separate attorney to help you out with those things.
Wonderful. So do you recommend people using a forensic accountant to assist with understanding where money went or for prosecution?
You can use a forensic accountant. They do exist out there. They're really great. I'm going to be in trouble with my analyst on this one because he just got certified, and I can't remember what his new fancy certification is. But you don't have to necessarily have a forensic accountant or a fancy analyst. Sometimes it's just somebody who can just sit down and walk through the numbers. If you have an investigator who is just willing to sit down and look at the bank records and follow the money, and sometimes that's all you need. We just got our analyst in January of 2019. So we haven't had our analyst for very long. And before that, we just had investigators just walking through and following the money on their own.
Awesome, thank you. So the next question, what is the benefit of going to the AG versus just getting an attorney?
The Attorney General's office most of the time just handles criminal matters. So if you're reporting a criminal matter, that's when you want to go to the Attorney General's office or your local law enforcement or your local prosecutor. You can go to your own civil attorney at any point in time. Whether you have a criminal case going on or not, you can go and seek out your own civil attorney and they can help you out through the process. If a civil attorney thinks that criminal charges should exist, many times the civil attorney is going to reach out to the local prosecutor or the local Attorney General's office and talk to them about possible criminal charges. So the two may work together if you start with a civil attorney.
So let's see, it looks like there's one more question in here. If a resident doesn't have a power of attorney or advance directive and is no longer able to make decision on his or own, can a doctor sign for him?
No, a doctor cannot sign for him. A doctor can sign off saying that they are not mentally capable of handling things themselves. But if someone is not mentally capable of handling matters financially or medically for themselves, then someone else needs to step in and get that power of attorney for them. Normally it's going to be a family member or a friend. Sometimes the Department of Human Services or the Department of Social Services in that state may end up having to step in as well. They try not to. They prefer having family and friends do it instead, but that would be what needs to happen. Unfortunately, the doctor cannot just step in and do it.
So this is kind of related to a previous question, but it says, what factors make fraud a case for the AG's office or a private attorney?
The AG's office, the factors for fraud for the Attorney General's office is based on criminal statutes. So it has to be a crime for the Attorney General's office to come in and charge it out as fraud. Most of the time, the criminal statutes say it's some type of financial exploitation as a criminal charge, or they say something like a type of theft is a criminal charge. Now, there are civil charges that exist out there where you can go and just get monetary compensation for fraud. And that's, those civil charges are completely separate than the criminal charges. Many times the civil charges can be, and I'm trying to think of them because unfortunately I don't do the civil cases. That's what we have other attorneys out in our state for. But they come in and do like indemnity, contempt of court, failure to do fiduciary obligations, some things like that exist. And those would be existing in the civil section. Where you're just getting a monetary, asking for a monetary result, whereas criminal charges, you're asking for specific crimes where that person can be sent away to jail. They can have a fine given to them by the judge, but the judge could also ask for the restitution, which would be a dollar amount to try and make the victim whole. So hopefully that answered that question with those two distinctions.
So we have one more. If an individual sets up an LLC instead of doing a trust and it appears there is fraud and possible undue influence from two of the children, how difficult is it for the members to have the LLC be dissolved and have it moved to a trust? Sounds pretty complicated.
That is a little complicated. Most of the time in that situation, you're probably going to need to go seek outside help from a civil attorney to go through the process of dealing with the corporation and how the corporation was originally set up, because they may have specific language in the corporation about how it can be dissolved, and then how you would set it up as a trust. So the best way is probably, unfortunately, is going out and seeking help from an outside civil attorney.
Wonderful. Well, I have a question, since it doesn't look like there's any more questions in the chat box, but I was at an estate planning presentation last week, and one individual said that somebody had power of attorney and they used power of attorney to change a whole lot of the estate planning stuff that had been put in place prior, previously by the person. So how is that something that could possibly be elder abuse, making those changes like that to the estate planning once a person has power of attorney?
It's possible. Unfortunately, in that situation, you have to go back and look at the power of attorney itself and see what the document says that person can and cannot do. Okay. That's why I really stress knowing what you can and cannot do. Yeah. Because there are some documents that may say that they're allowed to do those changes to the estate plan, and they exist out there, unfortunately.
Oh, right on. So that's just really buyer beware when you're setting up those things, to make sure that power of attorney doesn't allow somebody to make massive changes like that if you're not comfortable with it.
That's correct.
So if there is another question, if there is a POA in place and they are no longer willing to be in that role, can an elder who has questionable capacity, some memory issues at 90 years old, can POA be identified by that client, or POA be transferred? So
the POA,
go ahead. No.
The POA can always be transferred, but again, it goes back to, does the original power of attorney state that there's a substitute power of attorney? Because sometimes the power of attorney may say that Johnny is going to be the power of attorney, and if Johnny says he doesn't want to do it, Susie can be the power of attorney. So sometimes it's already written in the document. If somebody chooses not to be the power of attorney anymore, they have that alternate already written in there. If it's not written in there, then the person who originally created the power of attorney can quit the power of attorney, basically dissolve it, and create a new one if they choose. Or if it is determined that they don't have the capacity to do it, someone can possibly come in their shoes and change it. Also, the power of attorney, say it was Johnny who doesn't want to be power of attorney anymore, he can go in and most of the time dissolve it himself, and then no one becomes power of attorney at all.
Wow, that's pretty interesting. There's a lot to keep track of. Don't see any more questions so far in the chat box. We've got about 3 minutes left. Kimberly, do you have any closing words you'd like to share with the group?
Just, if you're going to do any of these types of documents, most of the time check with somebody. I know a lot of people don't want to spend money and go to a civil attorney, but sometimes just going in and have that initial consultation with them sometimes is just very beneficial, and you can get an idea of what you want and what you don't want. And if you see anything that you think might be abuse, please report it. You don't have to distinguish between is this a caretaker who's just frustrated, or if it's somebody who's actually abusing. Leave that up to law enforcement and prosecutors. But if you question anything, just report it. A lot of these cases happen because somebody saw something and said something. And I know it's very cliche, and it's been used in a lot of different scenarios, but if you see something, say something. So we need everybody's help to protect our elderly and our adults with disabilities. So if you see something, say something.
So the last follow-up to that one question was, so in that case, if that person says, okay, I'm no longer power of attorney, and there's no power of attorney for that person with questionable mental capacity, they would need to have a guardianship put in place, probably, right?
They could. That might be the resolution that ends up happening, is going and getting a guardianship put in place. And that's something that if the power of attorney wants to dissolve, that person can probably go into the court and say, hey, I'm going to dissolve the power of attorney, but I think a guardianship needs to be put in place. So that is one resolution that could happen, yes.
Awesome. And then back to the LLC, if a member is committing fraud, is that more difficult to report as criminal?
Not necessarily. Again, if you think something is criminal, report it and let the law enforcement, the people who are trained to deal with crimes, figure it out. But it all depends on what's written down and what's there. Most of the time, if you're on a board of directors or if you're part of a company, if you see fraud of any type, you're required to report it. So report it to your board of directors and go ahead and report it to law enforcement if you think that's what's happening.
So we got one more question. Does a POA need to be on file for other family members to see it?
No, it does not. Anybody can see a power of attorney. If you want to give it to them a copy, it is always helpful if you do file one, just so then other people, especially if you're working with a lot of third parties, it is helpful for them to go find it and see it. But you don't have to have it filed to show other people.
And I just want to add, I would recommend having a conversation with family members about who was identified as POA and why, because you don't want that to come out when you're incapacitated and then all of a sudden there's stress and there's drama because someone's offended that they weren't selected to be POA. So that's just a piece of advice.
Yep.
Thank you all so much. We're at the top of the hour again. We will send the recording and the slides out to you. Thank you so much for spending this hour with us. We will send out an evaluation link. Please give us feedback. In that evaluation, you can always sign up to be notified about our upcoming webinars. Thank you again for your time.